What if I told you that there's a way to get your E-2 visa approved without risking your entire investment up front and bring your family along? Most people think you have to hand over all your money and just hope it works out. And they assume that adult children are out of luck. But this case shows there's a smarter way to structure both the investment and the family applications. Let me show you exactly how. Okay, so here's the situation. A foreign investor wanted to buy an established seafood restaurant in a coastal US town for $210,000. She had a husband, a daughter under 21, and an adult son who all wanted to come to the US. So right away, we're dealing with three big questions. How do I protect my money? How do the dependents come? And what about the adult son? The answers are different for each. Let's break down exactly how this worked. Here's the key part. Out of that $210,000 purchase price, she put $175,000 into escrow. The remaining $35,000 was seller financed through a promissory note. Now, what does escrow actually mean? It means the money sits in a secure account that is controlled by a third-party escrow agent. The seller can't touch it. The buyer can't pull it back. And in this case, the money wouldn't be released until the visa is approved. This is where people get nervous. They think, wait, if the money isn't released yet, how is this an at-risk investment that will satisfy the E-2 visa requirements? Fortunately, the Foreign Affairs Manual guidance is clear on this. Funds held in escrow for release upon visa approval still count as irrevocably committed. The commitment is real. The agreement is signed. The investor has skin in the game. And to make this particular case even stronger, the investor also had operating capital that exceeded the $35,000 in seller financing. Plus, she'd already spent about $11,000 on legal fees, business planning, and setup costs before the visa was even approved. That shows serious commitment. So when you look at the total picture, escrow funds, operating capital, and expenses already paid, the investment was clearly substantial and at risk. Bottom line, escrow isn't a loophole. It's a legitimate risk management tool that protects investors while still satisfying the at-risk investment requirement. Now let's talk about the family piece, because this is equally interesting. E-2 visas allow dependent spouses and their children under 21 to come along as derivatives. But there's another path that people don't always think about. In this case, the investor's adult son applied separately as an E-2 employee in a managerial role. He wasn't coming as a dependent. He was coming based on his own qualifications to manage the restaurant. And he was actually qualified. MBA, years of management experience. He could demonstrate that he had the skills to run day-to-day operations. Meanwhile, the investor's husband and daughter under 21 applied as derivative family members. This is the key distinction. The son had to prove that he qualified as a manager. That has a completely different standard than a derivative application. The derivatives just need to show the family relationship. Marriage certificate for the spouse, birth certificate for the daughter. So you had three different application types in one family. You had the principal investor, you had a managerial employee, and two derivatives, each with its own requirements. So why did this case succeed? Here are four reasons that matter for anyone who's still watching this. First, the proportionality test. The investment was substantial relative to the cost of the business. The purchase price was $210,000, but only $175,000 was in escrow. The remaining $35,000 was seller financing, which doesn't count toward the at-risk investment total. But she also had operating capital that exceeded that $35,000 gap. Plus, she'd already spent money on legal fees, business planning, and setup costs. So when you tally up the escrow funds, the operating capital, and the at-risk expenses already paid, the total qualifying investment was substantial. Second, the escrow structure aligned with the Foreign Affairs Manual. The manual specifically contemplates that a purchase conditioned on visa issuance can still be irrevocable if the assets are held in escrow. We weren't inventing something new. We were following established guidance. Third, the business was real and active. This wasn't some speculative venture. It was an operating restaurant with employees, revenue, a lease, and a track record. Fourth, the son's qualifications were legit. He wasn't just a family member trying to tag along. He had an MBA and actual management experience. When the consulate looked at his application, they could see that he genuinely qualified for a managerial role. That matters. The family structure worked because each person's application was solid on its own terms. So here's what this means for you. If you're nervous about committing a big chunk of your life savings before you know if the visa will be approved, talk to your attorney about possible escrow options. Not every case will work this way, but it's certainly worth exploring. And if you have family, understand your options. Your spouse and kids under 21 can come as derivatives, but adult children over 21, they need to qualify on their own merits, usually as essential employees or managers. The key word here is qualify. They need real credentials, real experience, a real role in the business. You can't manufacture this. This case shows you that you can structure it so multiple family members come together, but each person's path needs to be planned carefully and honestly. I really enjoyed working on this case, and I hope this example is helpful. But remember that this is not legal advice. Every E-2 case is different. What works in one situation might not work in another. The consulate matters. The business type matters. Your specific facts matter. But the lesson here is simple. You can sometimes structure these deals to protect yourself. You don't always have to choose between reducing your financial risk and approval.